if a Hindu commits the murder of a person, he is punishable under section 302 of IPC. If a Muslim commits or if a Christian commits the same offense, he is punishable under the same law. So, lot of laws which are in India do not have any religion perspective or a caste perspective. They are applicable throughout the country. The state shall not deny to any person equality before the law or the equal protection of the laws within the territories of India. That means no discrimination should be done to anybody. We have heard the word workshop. What's the difference between a seminar and a workshop? Seminar is one where deliberations will take place to take an appropriate decision. So it is in this direction seminars will be held. Workshops will be held to find out the modalities of implementing the decision taken. So we are at a very nascent stage of discussion. This discussion has been taking place ever since we accepted our constitution to ourselves with effect from 26/11/1949. Some of the provisions of the constitutions had not been given effect to, and ultimately they were given effect to on 26/1/1950, and therefore we call it as our Republic Day. India is a sovereign democratic republic. The words secular and socialist were added by 42nd Amendment, which were done during emergency. Whether India was not a secular state, whether India was not a socialistic state, prior to the introduction of those two words in the Constitution has been a great debate. As rightly pointed out by Sri Nagaraj, we have always assimilated any religion which came to India, any tribe which came to India. We have never opposed. The basic tenet of the Bharatiya culture is to take everybody onto our fold. Therefore, we were socialist, we were secular. What does the word secular means? Secular means all religions will be looked after or taken in right perspective. Whether did we not take all the religions in right perspective prior to 42nd constitutional amendment? We were. Friends, Mr. Nagaraj has given an excellent perspective so far as the historical perspective and the Indic perspective is concerned. This Uniform Civil Code finds a place in the Constitution. Article 44. What does Article 44 says? The state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. I will read it once again. The state shall endeavour. State means whether it is central government or the state governments. Because under Article 12 of the Constitution, the word state is defined. The state shall endeavour means make an honest effort. For what? To secure for the citizens a uniform civil code throughout the territory of India. We have already several laws. Transfer of Property Act. If I want to sell a land or my house to you, whether the purchaser is a Hindu or a Christian or a Sikh or a Muslim, Transfer of Property is Act applicable. If a property which is worth more than 100 rupees, it shall be transferred through a registered deed only. There are provisions in the Transfer of Property Act. If I want to enter into a contract, let us assume that I have 2 acres of land and B wants that land to build a residential complex, and he can enter into with me a joint development agreement agreeing to give some of the built area in lieu of the land given to him and in lieu of the amount spent by him too. So this is covered under the Contract Act. So far as applicability of several laws in India, no question of religion arises. For example, if a Hindu commits the murder of a person, he is punishable under section 302 of IPC. If a Muslim commits or if a Christian commits the same offense, he is punishable under the same law. So, lot of laws which are in India do not have any religion perspective or a caste perspective. They are applicable throughout the country. Earlier we used to see, let us assume that this law is applicable except to the state of Jammu and Kashmir. Now, from August 2019, even that has also gone away. Thanks to those who took a firm decision in abolishing Article 370 and 35A. So we have a constitution. So we have adopted a constitution unto our results. Nobody has imposed us. The Constituent Assembly dwelt over this matter with all seriousness for 2 years, 11 months and 16 days. 2 years, 11 months and 16 days. Almost 3 years. And great doyens, legal doyens, persons who had wonderful social connections were the members of the Constituent Assembly. Pandit Jawaharlal Nehru, Sardar Vallabhbhai Patel, K.M. Munshi, Alladi Krishna Swami Iyer, Meenu Masani. They were all the members of the Constituent Assembly. The people had been drawn from different religions so that there could be appropriate representation. Of course, that representation got tilted a little because of the partition, as few members went to Pakistan, migrated to Pakistan, newly created Pakistan. Now, in this constitution, we have several chapters, and out of them, 2 chapters are very important. Chapter 3, Part 3, Part 4. Part 3 consists of fundamental rights. What are those fundamental rights? Fundamental right is Article 14. The state, what does it say? The state shall not deny to any person equality before the law or the equal protection of the laws within the territories of India. That means no discrimination should be done to anybody. But Article 15(1) of the Constitution of India is like a proviso. It's an exception. What does it say? State shall not discriminate any citizen on grounds of religion, race, caste, sex, place of birth or any of them. That means I have one gender. So I am a male, somebody is a female. There should not be any discrimination on the ground of sex, gender. But Article 15(3) of the Constitution of India is an exception, acts as a proviso to Article 51. What does it say? State can make appropriate laws for the protection of women and children. What does it say? It further states that in spite of Article 15(1), the state can make laws for the protection of women and children. See, why special laws for women? Why special laws for children? Women had been subjugated to various restrictions for centuries together. This was taken cognizance of, and therefore special laws were made for them, have been made for them. How about children? For children also. For example, if an adult lady is subjected to rape, it is something different because Section 376 takes place. But children have also been subjected to sexual atrocities, whether boy or male, boy or girl. So there is a special statute has come into effect that is called as POCSO Act, Prevention of Children from Sexual Offence Act. Because the legislators have thought that if a child is subjected to sexual assault at such a young age, its growth, both physical growth and mental growth, will be tarnished. So that law is made in terms of Article 15(3) of the Constitution of India. Representation to the women have been given in, say, panchayat, municipalities, corporations, reservations for women in appointment. Because when we were young, only few girls used to come to high school, and even if they had scored good marks, they had no opportunity to go to colleges. So they were subjected to so many restrictions. We are witnesses to such restrictions. Probably youngsters may not have seen those restrictions being put on women and children. We are witnesses. Myself and Nagaraj are witnesses to such restrictions. No, whether those restrictions are proper, valid, by no stretch of imagination we can consider them as proper restrictions. Therefore, in order to ward off those restrictions put on women and children, several laws have been made by various states and the central government. Now, this Article 44 finds a place in not in fundamental rights. It comes under Part 4, Directive Principles of the State Policy. If there is a violation of any fundamental right, it is justiciable in any constitutional court, either by invoking Article 226 of the Constitution of India in High Courts or under Article 32 of the Constitution of India. But if, let us assume that the provisions of this directive principles of the state policy are not given effect to, the aggrieved party cannot go to a court because they are not justiciable in courts. Article 37 states, it is also in directive principles of the state policy, directive principles of state policy are not enforceable by any court, but it adds a caveat. However, the principles laid down are fundamental to a country's governance. So, when making laws, the legislators will have to keep in mind the provisions found in Part 4 of the Constitution of India, which are called as Directive Principles of the State Policy. For example, we have a Karnataka State Pollution Control Board because it takes care of damage to the environment. Where do we find Article 40? These directive principles of the state policy state that appropriate laws be made to protect the environment. Is it not? So, when a conflict arises between the fundamental rights on the one hand, fundamental rights found in Part 3, and directive principles of the state policy found in in Part 4, what court should do? There are umpteen number of decisions of the Honorable Supreme Court that under such circumstances, we must not dispose of the case. No, provisions found in a Part 4 are not justiciable in courts, therefore dismissed, therefore uphold fundamental rights. No, the court should make all efforts to fine tune and make a balance. Now, this Article 44, now the greatest criticism against Article 44 is, sir, it is not found in Part 3, it is found in Part 4, just give it up. The framers of the constitutions who worked day and night for 2 years, 11 months and 16 days were conscious of the same. As rightly pointed out by Mr. Nagaraj, there was some opposition from some quarters in the Constituent Assembly. They did not want to take a hurried decision to put it up in Part 3. They thought that appropriate government and at an appropriate time will make suitable laws with regard to Uniform Civil Code as indicated in Article 44 of the Constitution of India. Now our Honorable Prime Minister, Mr. Narendra Modi, made some pitch with regard to the bringing of Uniform Civil Code in one of the political speeches. Now we have been seeing every day lot of criticism. Now the important point we'll have to see is as to whether whoever speaks of conducting a debate on Article 44 of the Constitution is at fault. No, Constitution itself provides that state shall make all its efforts, endeavor to make appropriate laws to secure a uniform civil code. So therefore the debate now today held in Mythic Society is in continuation of Article 44. Why should anybody find difficulty when a debate takes place? Participate. If you have a view, please let it also be expressed. 5 members of the Constituent Assembly opposed. The then chairman of the drafting committee, Dr. Baba Saheb Ambedkar, took note of the same and said, and on a consensus, it was decided not to bring it within the purview of Part 3, to bring it within the purview of Part 4 of the Constitution. and with a fond hope that an appropriate government at an appropriate time would make all its effort to bring a uniform civil code. What is this code? Code means set of laws. What are those set of laws? We have laws for all other things applicable to all sections of the society irrespective of the religion. But so far as marriage, then succession, inheritance, we do not have uniform laws. I will give a background. Before 1956 and before 1955, Hindus were all governed by Shastric law. One was Mitakshara law and another was Dayabhaga law. Mitakshara law was applicable throughout India except Bengal. Dayabhaga was applicable only in Bengal. So, there were many schools of thoughts. So, as rightly pointed out by Mr. Nagaraj, Pandit Nehru also thought of giving a serious issue with regard to Article 44. But he felt that it would be counterproductive so far as getting votes is concerned. Therefore, it was given up. But Hindu laws under the Shastric laws, they were all codified. Hindu Marriage Act came in 1955. 1956 Hindu Succession Act, Hindu Adoption and Maintenance Act, and Hindu Guardianship and Wards Act. All these laws pertaining to personal laws of Hindus were codified. In fact, the then President of India, Dr. Rajendra Prasad, had opposed it. But in spite of this, the Hindu laws, Shastric Hindu laws were codified, and now as a result of the same, several progressive steps were taken. Till then, it was very difficult for a Hindu woman to get a divorce. It became easy because of Hindu Marriage Act. It was very difficult to get maintenance. So, Hindu maintenance. Adoption also, it was a very difficult question of adoption. And even if one were to execute a will, whether he could execute a will in respect of his undivided share in a joint family, there was no provision for such. There was no scope for executing a will in respect of an undivided share. But under Section 30 of the Hindu Succession Act, now a Hindu can will his undivided share to anybody he likes. So, Hindu laws were codified. As a result of one more important law came into being so far as marriage is concerned, whether there can be a interfaith marriage. So, Special Marriage Act 1954 takes care of this. So, though there was some initial opposition for codification of Shastric Hindu laws, ultimately all of us are now okay with them. As a result of that, now from 2005, 9/9/2005, a Hindu woman has got equal right even in respect of ancestral property. Earlier to that, earlier to 9/9/2005, if a partition were to take place, Hindu wife would not have got, Hindu daughter would not have got anything. Even if her father were to die, she would get only a very minor share in the notional share that would be allotted to her father. But now the whole scenario has changed. So, a Hindu daughter is entitled for an equal share along with her brother or father. And that has come into being from 9/9/2005. A judgment of the Supreme Court in Vineet Sharma's case has even held that no question whether she was married or not, if partition had not taken place, even if she is married, she is entitled for an equal share along with her brother or father. So, a new dimension to the status of woman. Have you opposed it? Hindu woman. Okay, Hindu woman. Now, we must also think of, as a result of this enlargement of the share of the daughter, the share of the widow has come down substantially. I have written an article also. Courts, I think, will take up, or the legislators will take up. As a result of the enlargement of the share of the daughter, the share of the widow has come down. Where should she will be aged? She is not interested to go to her son's house or daughter's house. Because of age, she will not be in a good position to take care of herself. So therefore, it is high time that some amendment is also made to take care of the interest of such women who are deprived of their proper rights. So Hindu society, as rightly pointed out by Nagaraj, is always amenable for good changes. It has never opposed. It doesn't mean that the others are opposing it. But there may be opposition. Opposition must be for valid grounds. So we will have to throw some light as to what was discussed in the Constituent Assembly when the discussions were in progress. I would like to say few members. K.M. Munshi, he was a great lawyer from Bombay, Kulapati Munshi. He had participated, and his view is as follows. This is found in the Constituent Assembly debate. Mr. K.M. Munshi said, quote, "The whole object of this article is that as and when the Parliament thinks proper, or rather when the majority in Parliament thinks proper, an attempt may be made to unify the personal law of the country." So, what was the reply of Dr. Ambedkar, the chairman of the drafting committee? The chairman of the drafting committee, Dr. Ambedkar, while replying to the question on the provisions of the UCC in the Constituent Assembly by the minority community, said it was intended to have a code which provided for uniformity of laws in matters of marriages, divorce, succession, irrespective of religion, community, etc. Muhammad Karim Chagla was one of the finest judges that India has ever seen. He was the Chief Justice of Bombay for more than 10 years. He was a great nationalist. What has he observed? He has stated, Article 44 is a mandatory provision binding the government, and it is incumbent upon it to give effect to its provision. The Constitution was enacted for the whole country, and every section and community must accept its provision and its directives. Now, another member who had participated in the constituency proceedings was Alladi Krishnaswamy Iyer. He was also a great legal legend. Nobody can undermine his contribution with regard to Article 29 and 30. Being a Hindu, it was his contribution to Article 29 and 30 of the Constitution of India, minority rights. I will deal with that at a later point of time. Please see, an important case was decided by the Honorable Supreme Court way back in the year 1985. It was a Constitution bench judgment. A judgment given by 5 judges or more of a Supreme Court is called as Constitution bench judgment. It was presided over by the then Chief Justice A.V. Chandrashekara, father of present Chief Justice D.Y. Chandrachud. A lady, a Muslim lady, approaches a trial court under section 2025 of CRPC for maintenance, as he had divorced her by talaq. Maintenance was granted in her favor. He appealed, filed a revision, lost it. Then he took up the matter to the Supreme Court. Supreme Court ultimately held. So, section 125 of CRPC, which deals with granting maintenance to divorced women, is applicable irrespective of religion. And there was hue and cry. Muslim fundamentalists opposed it, as a result of which Rajiv Gandhi's government brought a new law called as Muslim Protection Divorced Women Protection Act of 1996. That was also ultimately decided, interpreted by a Constitution bench judgment, and held, irrespective of this act, she can approach the court and take maintenance. Why I am dealing with this is, so far as maintenance is concerned, Madam has rightly pointed out, no discrimination can be made on the grounds of religion, whether a Muslim woman or a Christian woman or a Sikh woman or a Hindu woman. If she is divorced, she should get a reasonable maintenance so as to avoid vagrancy. So then came this Shaheria no Bano case with regard to talaq. The practice of divorce, which was prevalent amongst Indian Muslim men, was to divorce them by uttering talaq 3 times. Whether it is an essential practice in the religion was considered, and it was tested on the touchstone of Article 14 of the Constitution of India, whether it was a discriminatory practice. Such religious practices which do not conform with the Article 14 of the Constitution of India, the Constitution bench by a majority of 3:2 held that talaq is a regressive step to divorce, and now on the basis of the judgment a new law has also been made. And have the Muslim women opposed it? No. In fact, they were anxiously waiting the Supreme Court to pass a law to uphold that talaq is regressive. And the law made by the Parliament pursuant to the judgment of the Supreme Court is also held to be constitutionally valid. My only intention is to say that if we are at a very nascent stage, Uttarakhand state has just had constituted a committee to look into as to whether the provisions of Article 44 of the Constitution of India can be implemented in the state of Uttarakhand, because it is found in concurrent list. Because state government can also pass legislation, central government can also pass legislation, but only inhibition is this: when a state legislature passes a legislation on a concurrent subject, it must be in conformity with the law that would be passed by the central government. Now, of course, the report submitted by the expert committee with regard to UCC is not yet published in the public domain. It is still with the state government. We have to make a honest effort. This effort, as rightly pointed out by Mr. Nagarajji, there must be a widespread debate. Article 44 provides for such a debate, and that debate has to take place in a very vigorous manner to find out an appropriate decision. We are cognizant that India is a land of many religions. India will take care of our irrespective of governments which come into power. They will take care of the interest of all the members of all the religions. There need not be any apprehension. And just because a debate takes place in a public fora with regard to the implementation of Article 44, nobody should find any fault. And I am very confident that seminar of this type is organized by Spandana Trust. I congratulate the members of the Spandana Trust for having taken this initiative. Let this initiative spread rapidly. Let all the views come. Now, Union Law Commission has also taken up this subject. People had been given opportunity. All of them have submitted their own views. It will be considered by a body which is headed by a former Chief Justice of this court itself, Mr. Rutiraj Avasthi. Hope things will follow in an appropriate line, and we will find out an appropriate decision. I am extremely grateful to the organizers for giving me an opportunity and to speak a few words on UCC.